On the record, Chairman.
Thank you. Good afternoon. This is case D 2021-627-261, the Kaloustian matter and Montano matter. We are on the record. We have the plaintiff present in court, and we have the defendant present through the Blue Jeans application. So, sir, why don't you state your appearance? Just state your name.
Ari Kaloustian.
Thank you. Ms. Montano, state your name.
Edith Montano.
All right. First, I apologize for how late we're being called. We've had a really busy morning. I know you've been waiting for a long time. The court has reviewed the papers in this case. We had a hearing in November. A custody decree was entered. The material provisions of that custody decree were the parenting agreement that you entered into that was filed on October 13, 2021. It provided for joint legal custody. It had a detailed timeshare provision. Mom had primary physical custody of the party's child that is 2 years old. It was a child support order, and the case was closed in November. So, sir, you reopened in April. You said that you needed help from the court with orders of enforcement, that it was not being followed to your satisfaction. She filed a response in opposition last week. Did you get it?
Yes, I did.
All right, so she's made a denial of the general notion that she's violated the order. She says that there's been communication issues and that there was a failure to pick up or whatever. So obviously your motion contradicts that, you know. And so I have this dispute I need to worry about. You agreed to a pretty detailed schedule. You got 4 different permutations of how to share custody. You got a certain timeshare Thursday morning to Saturday in weeks 1 and 3. You got Wednesday morning until Friday prior to and during the 2nd week, and during the 4th week, you've got Thursday to Saturday, but different times, 8 a.m. to 9 p.m. So mom has the child other times. So that schedule requires you to pay particular attention to what day it is, what week it is, that the exchanges take place. And it's not a good thing to have a case settled in October, November, and have problems right away. I mean, you're back in court 6 months later. So we want to try to make things better. We definitely want to enforce the orders. I need to consider tools that would help me understand who's responsible for not following the court orders. One of the things the court does sometimes is simplify the custodial schedule and order supervised exchanges of the child so that I know who's showing up on time and who's receiving the child. But, you know, it's no good to be in a situation where you have an order and for whatever reason it's not getting followed. It causes a lot of hard feelings. It's not in the interest of the child. And so we got to look at how we fix this, okay? Now, I didn't see a reply. Her opposition wasn't filed for a month, and it wasn't filed till like the end of last week. So you read her response. I assume that you disagree with the general notion that you haven't been showing up to pick up your child and things like that, right?
Yes, Your Honor.
Oh, you don't have to stand. You can just sit.
Thank you kindly.
So what are you asking the court to do other than require some sort of following of the timeshare provisions?
There has been several exhibits that I have filed in regards to CPS, in regards to finding certain things on the child, which...
Well, what does that mean? I mean, you're not asking to modify the court custody schedule. What you said suggests to me that you think that there's some sort of abuse and neglect substantiated.
Yes, Your Honor.
Well, how is that?
Well, essentially, there's, I know if you view exhibit number 4, the scarring of the child's body.
Oh, I know about it.
Right.
Is that before or after November?
After.
Okay, and who discovered that?
I did.
And did you call the Division of Family Services?
Yes.
Did they investigate it?
I would assume so.
All right, did they close the investigation as unsubstantiated?
I'm unaware of.
Well, okay, well then you should know the answer to that question. The court can help facilitate getting information concerning a family. they will produce their records, which will show me whether a communication has been made, whether they investigated it or staffed it. But it's your burden to show, if you make an allegation of abuse and neglect, that it occurred. Okay? And, obviously something like that is always relevant to custody. But you have not, basically what you alleged in your papers is that she's not picking up and dropping off the child as ordered. Isn't that what you said?
Yes, Your Honor.
All right, so are you asking the court to modify the visitation schedule to make it more simple? Or are you asking the court to enforce it? What are you asking the court to do?
I'm asking for the court to enforce it as well as modify.
Well, I'm in your motion, and your motion, I know you used the fill in the blank form, so it doesn't give you a lot of room to make a specific request, but this is what you wrote. You wrote one sentence. You said, the other party knows the court orders. The defendant has forwarded plaintiff a copy of the legal document via email. You said that you have Thursday at 800 hours to Wednesday at 2230 hours, the second week of every month. Well, that's not entirely correct, because the timeshare provisions of the order have a lot more detail in it, and there's a different schedule for, 3 different schedules by my count. So that's what's written on that page. Then you describe it as concealment, but you go through October, November, December, January, February, and April problems in which you had to make a report or document not getting the child, right? So that's, even if the agreement was October 13th, the first week after that was the first problem that you had.
Yes.
Yeah, so then you said that you received a phone call April 14th, and you said agent asked details to conclude investigation. So you say you want full custody and supervised visitation for the defendant, okay? The court isn't even going to reopen the issue of custody unless you provide what's called a prima facie affidavit showing material changes in circumstance affecting the welfare of the child and that it's in the best interest of the child, which means you have to document the changes since the agreement that you agreed to give her primary custody. And your motion, your motion doesn't even state the allegations that would constitute reopening the matter, let alone a change. Now, you did say that you wanted the child to attend kinder care.
Yes, Your Honor.
Kinder care is preschool, right?
Yes.
All right, that's a joint legal custody decision. You have joint legal custody. School is not going to be required for your child for a couple more years. You have Thursday and Friday some weeks. You have so Thursday and Friday are basically the days that you have the child on a routine basis, right?
If I may, Your Honor, I never actually agreed to give primary custody to the defendant. Unfortunately, during that particular time, I had a counsel, and unfortunately, I was being...
Okay, but all right. Well, I hate to hear that.
Right.
But, the parties approved the agreement at the hearing on October 13th. It was filed. The case was closed. It's now 6 months plus past the closing of the case, and so, this timeshare is where we start with this. Now, have you talked to Mom about preschool for the child?
Yes, I have.
Has she refused to agree?
She did agree upon when I noticed, when I concluded that the child had been abused or displays behaviors of abuse, and in which the defendant essentially stated that a previous babysitter or a person that would watch the child would utilize belts as an intimidational factor. And I also have video of the child utilizing his belt as a whip, essentially. So I have reason to believe that there
Well,
is...
the court, you have, and Mom have, limited rights of corporal punishment, but you don't have the right to use an implement or like a belt on the child. and neither does mom. Are you alleging that either one of you have used a belt in punishing the child?
No, I am not. I'm informing the court that the person that was watching the child was utilizing belts or a belt as an intimidational factor.
What is all these? I'm looking at you. You just filed like stream of consciousness, 250 pages of stuff. Some of it is you can't even see. They're just Xerox copies of photographs, but there's a lot of stuff. There's articles and other things that are in here.
Right.
This is all over the place. I can tell you that the court didn't read every line and every page here, and it was not even. It was filed after your motion. I don't even know if she received it, but what does this have anything to do with your request to enforce your rights?
Well, it's to essentially give you some information in regards to my personal character and that such. And
Well, okay, but look, we have an order.
right.
What the court is required to do is try to help you enforce your rights that have been reached by agreement and order. The court is specifically not saying that you get to start over and relitigate a 2021 case or 2020 case as if the mediated agreement didn't happen and the order didn't happen, okay? And I'm not judging your character or passing judgment on you or anything else. I have an order. We have a starting point. You have a lot of certificates of training and pictures of you and the child, as if you think that the court doesn't think that you have a committed relationship with the child or that you care about the child. That's not it at all. I mean, I'm just trying to, I mean, there's nothing in here that even would support a reopening of the case. So let me ask Mom a few questions, okay? Ma'am, are you a lawyer?
No, I'm not, Your Honor.
Do you work in the legal field?
I do work in the legal field. I work in personal injury, Your Honor.
All right. Well, the reason why I say that is that so many folks like you are not lawyers. They're dealing with these cases, and you went to mediation. You entered into this agreement. Your response in opposition that you filed last week says that the dad is responsible for not getting the child on his schedule, and there's no detail really. Did Child Protective Services contact you and advise you that they've been investigating any kind of allegation of abuse or neglect?
No, Your Honor. I have never been contacted by CPS, nor was I aware of any of those exhibits that he said he submitted.
There's no exhibits from CPS, okay? Who do you use for child care?
I use my friend's mother. My friend's mother that lives in North Las Vegas.
Right.
She takes care of her.
Are you aware of any allegations Dad had that a child care provider or babysitter, threatened a child with a belt? Do you know anything about that?
The dad mentioned to me that our son would jump when he would see a belt, and I would just tell him that his previous sitter would use like a belt, like as a sign of fear, but never hit him, never once touched him.
Well,
our son has regular.
Is that babysitter watching the child now?
No.
All right. Well, obviously you would. I mean, I assume that neither one of you would support anyone using corporal punishment with your child, right?
Of course not, Your Honor.
So, all right. Well, the court is going to order to see if there's any Division of Family Services records.
Okay.
They may not have staffed it at all. They may have received a report and just closed it. But the court is going to look at it.
Okay.
In the timeshare agreement that was made, the order of the court, there were all these different schedules: Thursday morning to Saturday afternoon, Wednesday morning to Friday evening, Thursday morning to Saturday night. What was the reason why you guys negotiated like 3 different schedules?
Your Honor, he requested Thursday morning until Saturday afternoon. That's when he would go back to work. However, I wanted to have a whole weekend, and I asked if I can have like Friday for me to pick up our son Friday after work. So because of that, he then asked if he can pick him up Wednesday after work. And that's the reason why that happened the second weekend of the month. The fourth weekend of the month, because he stated that whenever his family would come in town, he would want longer day on the Saturday. And we agreed to that. I have a set schedule, and I've worked in the legal field for several years. So my set schedule is Monday through Fridays. And I would like, my family's in California, so if I do travel, I would want to have the full weekend off. And that's the reason why I suggested that. As far as that's our scheduling, and he picks him up after he gets off of work Wednesdays, the second weekend.
Well, okay, but he's saying you're not giving him the child as ordered, and you're saying that he's not coordinating the exchanges or being there on time. So you see what the court's problem is? I don't know who to believe, and I got to have the order followed. So what's your suggestion?
Your Honor, it's really hard to communicate with him when I'm constantly sending him messages, even the day before, to confirm if he's going to come and pick him up on a Wednesday at 10:30. Because it is the evening, it is night. Our son does go to sleep early because we wake up early so we can, I try to have him on a schedule. Even though he's only 2, I try to go to sleep by like 9, 10 o'clock. And so I would want him to go ahead, communicate with me. I am on my way. That way I'm not standing outside going to go. He doesn't call me when he's there. He doesn't text me when he's there. Am I just supposed to come outside and just be outside waiting for him to show up at 10:30 at night? And even other times when he's scheduled to pick him up at 8 o'clock, he shows up at 8:20, 10 o'clock. Other times where he does not communicate with me. And I've suggested to communicate with him through our family wizard app, just because so we can avoid any harassment, any miscommunications, and we have everything more logged. So I submitted numerous texts as exhibits as far as how communication is with him.
All right, so you basically organized this so that you would have one weekend a month?
Yes.
Okay. And where do you work or live in town? What part of town?
I live by Spring Valley. I just recently moved, and I live in Spring Valley, where before I used to live where they used to watch our son. And it would be fine for me to go to work and leave him there, and his dad can show up at 8:20, 8:30.
When does your work day end?
At 5 o'clock.
Okay.
Fridays at 5 it ends. Mm-hmm.
And do you routinely go to California one weekend a month?
I've been going the last couple of months because my mom is an older lady and she's disabled, and so I try to go so my son can have a relationship with her. And it's harder for her to come over here, so it's a little bit easier for me to go over there.
Well, what I'm trying to do is I'm trying to get back on a schedule where the visitation order is followed. I'm not going to take time from Dad, but I may have to reorganize it to address some of the issues here.
Okay.
It looks to me like he returned on Saturday afternoon at 1, or Saturday night, except for the weekend when you got the child back on the Friday, right?
Yes, okay. I go pick him up. He picks him up, and I pick him up when he's with his dad.
Right, but if okay, and what weekend did you have? You had the second weekend of the month?
Yes.
All right.
Your Honor, but several times he has not gone to go pick him up.
Well, that's what I'm working on right now. Let me finish right
and he will not let me know, or he won't text me at all, or call me. And I've called him.
I get that. That's why I'm gonna.
Okay. And Your Honor, can I suggest for us to do the pickup or drop off in a public location like at Las Vegas Metro Police Station?
Again, you keep talking while I'm writing. I've got all that covered, okay? Why don't you hear the order, and then you can ask me whether you have any questions, okay?
Okay, Your Honor.
You have the child now?
Yes.
No, Your Honor. I do
You
not.
don't? Aren't you supposed to have the child now? I mean, or is it Wednesday?
Well, it's specific, it's the second Wednesday of the month.
Well, I know, but it's the first weekend. So you're supposed to have Thursday morning until Saturday this week.
Yes.
Okay, all right, that's fine. The, okay, so the court is rendering a decision. I'm summarizing it here, so I want you to listen. And if you don't understand it, then I will, I'll try to explain it, okay? We have a custody case and a custody agreement. That custody agreement was closed or incorporated into a decree of custody filed in November. Dad reopened the matter, and he's asked for two basic things. One, he has asked to change custody. And two, he's asked to enforce his visitation rights. He has stated no adequate cause and no prima facie case to reopen the issue of custody. And his request for full custody, called it or whatever, is denied. We're not relitigating the issue of the fact that you have joint legal custody with mom having physical custody subject to dad's visitation. Now what dad has alleged is he's alleged, beginning almost immediately after the agreement was filed, problems a couple times a month with him getting the child on time, and the court needs to address that. So what am I going to do? I have one parent saying I'm being denied or the child's being concealed, the term you used, and I have another parent saying dad's not showing up. So what the court is going to do is the court is going to get back on a schedule, the regular schedule. I'm adjusting the regular schedule, not to take time from dad, but to make it simple so that it's the same every week. And we're going to have monitored or supervised exchanges of the child temporarily. It will be at the family court. It'll be in a program called Donna's House Central. That is where you're going to contact them right away. You're going to tell them that you're going to be exchanging your child. And I'm going to have a hearing probably early August, mid-August. At that time, I hope that you'll feel better about the exchanges. Maybe you won't need the supervised exchanges anymore. It's not intended to be a permanent situation. It's a safety tool. But the program manager is going to tell me who showed up on time, whether the child was exchanged, and I'll have a better idea of whether or who is following the court order. Now, I can't use the services in the same way that you agreed, so I'm adjusting it slightly. The pickup is going to occur at the same day and time each week, and will end at the same day and time each week. The only adjustment is that mom will still have 1 weekend a month. It'll be defined as the second weekend of the month, defined as the second Friday. Dad will pick up the child every Wednesday at 6 o'clock. And mom will pick up the child or receive the child every Saturday at 1 o'clock. This is similar to the schedule you have. So Wednesday at 6.
Wednesdays at
Saturday at 1.
6 p.m.
6 p.m. Saturday at 1.
Saturdays at
1. Now what it is, it's a blend of the short week or the long week. I've tried to give you additional time when I was shorting you, but prior to the second weekend, you're not going to have any time because mom will have the child. So you will go from Saturday to Wednesday without seeing the child. So if your routine is to go to California with the child, you still have the child for that 1 week in a month. Now,
Okay.
if we have a date the 10th, that would be great, August 10th. There is a small fee for this. It's nominal. You need to contact them. It's at the family court on Bonanza and Pecos. It will get you on schedule. When we come back in 2 months, I want you to tell me you got all of the visitation that was ordered and that the exchanges took place. Maybe there's another place that we can do the exchanges, or maybe you'll like the schedule being the same, but we must have compliance with the order. If we don't have compliance with the order, we determine that dad can't make his ordered contact or isn't reliable on time or whatever, then we may have to deal with that. If we find that mom doesn't deliver the child to the pickups and drop-offs, that's the opposite side of the coin. That's the other problem that we have. But I suspect that what will happen is that this tool will be a reset. You will get the child as ordered. You'll have meaningful contact between Wednesday and Saturday each weekend except for prior to the second weekend. And the exchanges will be uneventful. You don't have to deal with each other. You basically go in, the child is waiting for you, you leave, and you'll see with the orientation. Now, when is the return?
How far out, Judge? I'm sorry.
Well, do you have August 10th?
Yes,
All right, August 10th at what time?
11 a.m.
Okay, August 10th at 11 a.m. will be the return. At that time, I'll say, are we good? How did we do? Did the exchanges take place? I'll get a report from the program manager telling me how many exchanges took place. Were they done well? And then you'll tell me, you know, do you want to go back to the former schedule or do you want to keep the schedule? Do you want to change the exchanges? So the motion to change custody is denied. The motion for a contempt hearing is denied. Ma'am, I'm not interested in having a hearing to determine whether you violated the order. We're going to handle this as an enforcement, and it's in the best interest of this child that we enforce the order. We've made some adjustments so that the Donna South Central pickups and drop-off services are available. I'm going to give you a copy of the order, and ma'am, the order will be electronically filed and you'll receive it as soon as it's filed. You need to contact Donna South Central. I don't know if you've ever dealt with them. You did mediation, it's in the same complex. And you're going to start this tomorrow. Now, if you cannot use Donna South Central tomorrow, because it's too soon, you need to do some orientation, the pickup will be at the entrance of the family court tomorrow at 6 o'clock. There's staff security there, it's a safe place, and so Donna's house will tell you whether or not they're able to do it right away, but you're not going to lose your time. This is prior to the first weekend of the month, Wednesday to Saturday. You'll return the child at 1 o'clock on time. If you can use Donna South Central, that's great. If you can't, it's the entrance of the family court. Now, if you contact Donna South Central today, you'll be fine by next week. Yeah.
Okay.
Question?
Well, there hasn't been any discrepancies on my part in regards to.
I don't know what you mean by discrepancies. You've alleged in general
Yes.
that you gave me a list by date, which was helpful,
Yes.
of what you call concealment or times when you did not get the child.
Yes.
Some of those you actually called the police and filled out an event card.
Yes.
Yes.
I did, Your Honor.
Right.
And the fact that the defendant is intransigent due to the.
Well, we're going to find out.
Yes.
I have, when we come back to court on August 10th,
Sure.
you're going to have an opportunity to ask the court to do something about that.
Okay.
Now, just because you allege it doesn't mean that the court has found that she wrongfully denied you. It's possible, if the court had a hearing, that she would persuade the court that there was some other reason why you didn't get your child. But I now am ordering monitored visits. For 2 months, we'll be in monitored visits. I have all the confidence in the world that I'm going to know whether the order's been followed, and that is the best approach to this. Now, if you were denied contact, one of the things you can ask for is make-up time or something like that. So I will defer that until the next hearing, okay?
Okay.
And so, ma'am, the best thing you can do as the custodial parent is to make sure the custody exchanges take place, that you follow the rules and the orders, and we've changed the pickups and drop-offs to be the same every week, Wednesday and Saturday, except for the weekend that you have.
That's fine, Your Honor. Yes, I understand.
Just do your best to try to make it better. I mean, it saddens me when I see parents who resolve their case and they don't get the benefit of that resolution. They're back in court right away. So,
Well,
yeah.
if I may,
Yeah.
there's a piece of literature I would like.
No. What do you mean piece of literature? What are you talking about?
It's in regards to the defendant sending
A what?
a message to a friend of mine that.
What about?
Oh, displaying how histrionic, over-the-top hyperbole and hysteria the defendant is in regards to everything that.
She's the defendant.
Yes,
Yeah.
yes.
Well, I don't, we're not
within
having an evidentiary proceeding today. You want, why is this important or relevant after I've made an order?
It's so that you're aware of.
Aware of what?
Of the defendant's behaviors and actions.
Well, I know what you've alleged. How are they any worse than what you've already alleged? Also, you shouldn't be showing the court stuff that hasn't been served. If that's not part of the record already, then you can make it part of the record if you want, but
Okay.
you don't come to court and just hand over stuff that hasn't been delivered,
Okay.
okay? Now, maybe you didn't have it because it wasn't sent until
It
recently or
wasn't,
whatever.
yes, you're
Yeah.
absolutely right, it wasn't sent.
Yeah, well, that happens. Look, we're not done today.
Okay,
We're taking a step that the court is using to try to correct the difficulties that have happened since the agreement, okay?
yes, Your Honor.
And I hope it'll be successful, we'll see.
And as I mentioned, I have a friend of mine that has been a witness to.
Yeah, well, what, you don't think that you're believable enough?
No, I am, but I
I-
like to go above and beyond,
I
so there
understand.
is
If
no
we have an
discrepancy.
evidentiary proceeding and witnesses are actually called, then we'll see, you'll identify that person and maybe we'll hear testimony from them. But right now, I'm accepting what you said at face value, and I'm accepting what she said at face value, and I'm issuing orders that I hope will help, okay?
Your Honor,
Yeah.
can we communicate through our family wizard or the parenting app?
Do you know what that is?
Yes, it's a better way.
No, I'm asking him. It's hard to keep. Our nonverbals are terrible when I'm looking at a screen or looking at you, but it's okay. Do you know what that is, sir?
No, I don't.
All right. There are applications out there, about a half a dozen of them, that divorced parents or separated parents use as a platform for posting information concerning their child. It's very handy. It's handy in the application and it's handy in getting the data. So like, let's say that your child had a doctor's appointment or a dental appointment, or let's say that there were school pictures that needed to be ordered. It would be a place where you could post information that she had, or you would post information you had, and you would each receive it. It's Talking Parents is one, Our Family Wizard is another, I forget, there's a couple other names. These are proprietary products, okay? Parties routinely agree to them, but because they charge subscriptions and things like that, I don't order them unless the parties want to. But you should look into it, because right now you're probably communicating by email.
Text message, Your Honor.
Text messages.
Which is essentially, more or less, it's the same.
Well, no, it's not, because texts are very impulsive. It's very easy to get a text or be stressed the minute you hear your phone ding and you see that it's her, okay? Believe me, there's a difference. And I see this stuff all the time because it's evidence in these cases. Look into it. Look into Our Family Wizard, Talking Parents. If you don't want to do it, I'm probably not going to order it. But it's a good suggestion. Most parties have some sort of way to post information concerning the child. It's better than email, it's better than text, in my opinion.
Right.
Okay?
Which, I mean, I have no problems of doing my due diligence of informing the defendant.
Yeah, I'm going to give you an opportunity to investigate it yourself.
Okay.
And she's not telling you which one to get, she's just throwing out a couple of the more popular products.
Yeah, which,
Okay? One's free. You got to pay if you print out or download it. The other one, I think, is, what is it, $100 a year subscription, something like that? So it's not
99.
expensive. But I want you to think about it before I order it.
okay.
I haven't decided. I mean, I don't typically order this stuff.
Yep.
But you might come back and you, after looking into it, and say, you know, I didn't like that wizard thing, but I like Talking Parents, so let's do that.
Well,
Or you may say I don't like any of them.
perhaps after everything with the 2 months of supervisory and that such, perhaps this will not
Yeah.
be needed.
Well, that's why I asked, what was my first question? Do you even know what she's talking about? So I'm going to give you time
Okay.
to look into it. Okay?
Okay.
All right, we're done for today. Stay well.
All right. Thank you kindly, Your Honor.
Yeah.
One.